Pam Bondi just cracked this entire case wide open. $127 million, 14 contracts, 3 shell companies, all documented in court filings submitted Thursday. She walked in with everything. I've been deep in this since yesterday. 4 hours straight, 2 complete read-throughs. The transcript alone is 214 pages. Here's what the major outlets aren't telling you. Bondi, Trump's hand-picked attorney general, his public defender, his most trusted loyalist, entered that courtroom Thursday morning, and by 4 p.m., she had delivered prosecutors a complete blueprint. Wire transfers, executed agreements, time-stamped communications. This isn't a rumor. This isn't speculation. This is recorded testimony sworn under oath, entered into the official court record. You saw the headlines. You saw Bondi testifies. Here's what was genuinely happening inside that room. Pam Bondi, former Attorney General of Florida. Trump nominated her for U.S. Attorney General in late 2024, confirmed in early 2025. For months, she functioned as the shield. Every investigation that surfaced, every subpoena that landed, Bondi was the barrier. Then the Southern District of New York began pulling on threads. Property deals, payments from foreign sources, LLCs that raised serious questions. And somewhere in the window between January and last month, Bondi made her move. Fast timeline. Federal investigators issued subpoenas weeks ago to 3 holding companies incorporated in Delaware. Not long after, Bondi's private attorney held 2 separate meetings with prosecutors. Then Thursday arrived. Courtroom 14B. Bondi took the stand, not as someone facing charges, but as a cooperating witness. Her immunity arrangement was finalized and signed the previous Monday. That's the background. Now, here's what makes this unlike every previous Trump legal story. Bondi wasn't observing from the outside. She wasn't offering theories. She was physically present in the rooms where things happened. She personally handled the documents. She was part of the conversations, and based on the transcript, her recollection is precise and complete. Now, the documents. The actual evidence. First filing submitted Friday. I went straight to page 34. The language reads, and I'm pulling this directly. The witness confirmed direct knowledge of 3 separate agreements executed between January 2025 and August 2025, each involving payments routed through intermediary entities. That's not analysis. That's the official court document. Translation. Bondi observed money being moved and knows exactly where it went. But this is the section that genuinely stopped me. Page 89, paragraph 47. Bondi testified under oath that she personally examined wire transfer records totaling $18.2 million, all sent to a Nevada holding company carrying 0 employees, no registered office address, and no traceable business activity whatsoever. I polled the Nevada corporate registry. That company was formally incorporated 6 days before the opening transfer hit. It was dissolved 11 days after the final payment cleared. Line those facts up. This wasn't disorganized. This was deliberately constructed. And honestly, reading it the first time, I went back and checked because I thought I'd made an error. Page 112, Exhibit F. Bondi turned over to prosecutors 47 emails exchanged between herself and 3 figures from Trump's immediate inner circle, every one of them from a concentrated 2-week stretch last spring. Subject lines included, pulled verbatim from the transcript, Reypus arrangement and offshore structure urgent. Sit with that for a moment. The former Attorney General of the United States just surrendered emails explicitly referencing offshore financial structures written and sent during her active tenure in office. I read through this twice. The architecture is consistent throughout. Funds moved through Delaware LLCs designed to leave minimal documentation. Agreements were executed through designated proxies rather than the actual principals involved. Whenever specific subjects entered the discussion, communications shifted to encrypted channels. Every piece of this is documented. Every piece carries timestamps. Every piece is independently corroborated by banking records prosecutors had already collected before Bondi ever took the stand. Now here's what the coverage is completely missing. Page 147, buried deep in the appendix. Bondi testified about a gathering at Mar-a-Lago in February 2025. 8 individuals in the room. Her exact words, reading directly from the transcript, I was instructed not to document the conversation. I was told this explicitly. And then she documented it anyway. Personal handwritten notes stored at her private residence surrendered to investigators last month. Those notes describe a $340 million development transaction connected to a foreign sovereign wealth fund. The deal was deliberately structured to sidestep CFIUS review. For anyone unfamiliar, CFIUS is the Committee on Foreign Investment in the United States. Its function is examining deals that carry national security implications. This particular transaction was engineered specifically to avoid triggering their oversight. BONDI'S personal notes contain the phrase, "They know the threshold, stay under." 3 additional subpoenas were issued Friday afternoon in direct response to this testimony. 2 former White House staff members, 1 current attorney on Trump's legal team. The Nevada LLC is now the subject of a separate federal investigation. According to court records, prosecutors formally requested banking documents from 4 international financial institutions, including one operating out of the Cayman Islands, within 72 hours of Bondi completing her testimony. That's how fast this is moving. And that's only the first document. Subscribe now. I'm running daily coverage on this. The filings are arriving faster than mainstream reporting can process them. I'll keep breaking them down into plain language. But fairness matters here. The opposing argument has genuine weight. Trump's legal team is characterizing this as a politically motivated prosecution wearing the costume of legitimate legal process, and portions of their position are worth taking seriously. First point, Bondi is operating under an immunity agreement. She is not a disinterested witness. She is someone who negotiated a deal to protect herself from prosecution. That fundamentally reshapes her incentives. Every word she delivers in that courtroom works in her legal favor. Second point, none of the transactions in question have been established as criminal yet. Complicated financial structures? Yes. Offshore components? Yes. But complexity alone doesn't constitute a crime. And offshore doesn't automatically mean fraud. Trump's lead attorney, who has represented him continuously since 2019, said Thursday evening, this is a disgruntled former employee telling prosecutors exactly what they want to hear in exchange for her own freedom. I don't accept all of that framing, but it's a legitimate argument that deserves acknowledgement. Here's the fuller picture on their case. Bondi's immunity deal creates direct incentive to produce results. Prosecutors do not offer immunity without expecting substantial return. That dynamic creates real pressure to deliver and potentially to exaggerate. The corporate structures at the center of this Delaware and Nevada LLCs are standard legal vehicles used by countless legitimate businesses daily. Their existence alone proves nothing. Legal voices without any stake in defending Trump have said as much. A former federal judge currently teaching at Georgetown Law stated Friday, the complexity of these transactions does not establish intent. Structure is not sufficient. You need considerably more. I'm not positioned to declare a winner here. From the prosecution's perspective, Bondi's testimony demonstrates conscious knowledge, deliberate design, and a systematic effort to conceal activity from oversight. From the defense perspective, Bondi's testimony was effectively purchased from a witness who needed to produce something valuable to stay out of a prison cell herself. Both interpretations can coexist. That's the genuine difficulty here. What I keep returning to is this. Bondi didn't arrive with words alone. She brought physical materials, emails, handwritten notes, wire transfer records. You can challenge her motivations. You can question whether she's a reliable narrator. What you cannot do is challenge the existence of the paper itself. The emails are real. The transfers are real. The timestamps are real. If this entire case rested on her verbal account, the defense argument would carry serious weight. But it doesn't rest on her words alone. Republican strategists are already constructing a betrayal narrative. Bondi abandoned the president who elevated her. That story is solidifying across conservative media right now. And there's genuine feeling behind it. Political loyalty carries real meaning in these circles. Bondi was presented as a true believer. Her decision to cooperate feels like a personal wound to people who trusted her. A former Trump campaign official wrote Friday night, she was family. This is unforgivable. That sentiment is real. It shouldn't be dismissed. What I can report is what the documents actually contain. They contain a documented paper trail that prosecutors now hold in full, delivered by someone who is present in those rooms. Whether that represents justice or calculated self-preservation depends on your vantage point. The evidence itself is what we stay focused on. This didn't emerge from nowhere. A year ago, the first fractures appeared. Bondi and Trump's core team disagreed sharply over how to respond to SDNY subpoenas. Her position was compliance. Their position was delay. Within months, Bondi was quietly removed from key internal meetings. The title remained. The access disappeared. Around the end of last year, her name appeared in a parallel investigation, not as a primary target, but uncomfortably close to one. Someone described to Politico on record as being inside the situation said simply, she saw the walls closing and made a choice. What unfolded follows a pattern that has repeated itself throughout both terms of this administration. Loyalty rewarded generously right up until it becomes inconvenient. Legal exposure managed individually, never as a collective problem. When real pressure arrives, every person discovers they are standing alone. Bondi watched Michael Cohen go through it. She watched Rudy Giuliani go through it. She observed firsthand what staying loyal past the point of legal safety actually costs. She reached a different conclusion. Every insider who has cooperated before ran the same internal calculation and arrived at the same place. The difference with Bondi is the level of access she carried. Cabinet-level access she carried. Cabinet-level access. Classified briefing access. Presence in conversations that should never have taken place in front of anyone who might one day become a witness. Prosecutors now possess all of it. People are asking why she maintained personal notes, why she preserved those emails. The answers could be insurance, instinct, or a quiet understanding that this moment was always a possibility. Whatever the reason, Thursday happened. Before Thursday, this was all inference and reporting. After Thursday, it is sworn testimony entered into the official record, hit like. The algorithm determines who sees this content. If you find this kind of detailed breakdown valuable, that button signals YouTube to put it in front of other people. 1 second of your time. Genuinely significant impact. Thursday, 2047 p.m. Eastern. Here is precisely what occurred. Bondi was under direct examination and was asked about a specific meeting. Oval Office, February 14th, 2025. She paused. She looked toward her attorney. Then she answered, I was present when the president discussed structuring the Doha Agreement to avoid congressional notification requirements. The room went completely silent. What followed? Trump's defense attorney immediately moved for a sidebar. Prosecutors requested a 15-minute recess. 3 reporters exited the courtroom to file within minutes, 23 minutes total. Then testimony resumed. Bondi walked through the details methodically. The agreement covered a $340 million development project located in Qatar. American partners, foreign financing, and according to Bondi, an explicit directive to structure the transaction below the thresholds that trigger mandatory reporting. Here's what the coverage overlooked entirely. While every outlet focused on the dollar figure, something else was happening simultaneously. Bondi named names, not Trump in isolation, 8 separate individuals, current and former government officials, 1 sitting member of Congress. The transcript was partially sealed within an hour of that testimony, but reporters had already captured the core of it. Friday morning, one of the named individuals publicly announced new legal representation, retaining a prominent white-collar defense firm based in Washington, and released a statement categorically denying any wrongdoing. No one had requested his comment. He offered it voluntarily. That tells you something. The congressman's office issued no statement and directed all press inquiries to legal counsel. That also tells you something. The judge's response, an emergency status hearing scheduled for Tuesday with an accelerated overall timeline, not a reactive move. A deliberate one. The docket entries make that clear. Prosecutors filed for expedited discovery Friday afternoon and received approval within hours. Something contained in that testimony pushed the entire proceeding into a higher gear. This is where it becomes genuinely significant. The sealed section of Thursday's transcript, we don't have visibility into its contents, but we know it was sealed on the prosecution's initiative. They are protecting something, someone, or a sequence of events they are not yet ready to surface publicly. Tuesday begins to answer those questions. Leave your prediction in the comments. What do you think is in the sealed portion? Who else gets named when it opens? I'll return to this comment section following Tuesday's hearing and see who read this correctly. Here is what legal professionals are saying. Former assistant U.S. attorney with 17 years at SDNY When a cabinet-level official cooperates and arrives with documentation created at the time events occurred, that is not a minor development. That is a fundamental shift. In plain terms, this is rare. When it happens, the pace of proceedings changes dramatically. Criminal defense attorney with 22 years of federal practice, the immunity agreement communicates everything you need to know. Prosecutors do not extend immunity unless the value of what they receive exceeds the value of what they surrender. She had to deliver something that outweighed her own potential criminal exposure. Here's what's striking. Former advisors who served Trump are privately acknowledging the seriousness. One former White House counsel told CNN Friday the documentation is where the real problem lives. You can discredit a witness. A wire transfer confirmation does not have credibility that can be challenged. When people on opposing sides of a dispute begin agreeing on the same point, that point deserves serious attention. Where legal analysts are collectively landing, BONDI'S testimony in isolation is not sufficient to produce an indictment, but it opens avenues that were previously inaccessible. The physical documentation she provided can be verified independently of anything she says. That is the actual threat to the defense. The sealed section signals additional material is being prepared for introduction. Grand juries do not reconvene without purpose. A constitutional law professor at NYU published a piece Friday evening. What we are observing is a functioning stress test of whether the legal system applies uniformly, regardless of who is being examined. That question does not yet have a final answer. A former senior DOJ official from the Obama administration, currently at Brookings, this brings together elements that have not previously appeared in combination. A cooperating cabinet officer, active, concealment allegations, foreign capital, congressional entanglement. Any one of these alone would be significant. Together. She stopped there. The sentence completed itself. That is where the professional assessment sits. The legal process is in forward motion. The question is no longer whether exposure exists. The question is how broadly it extends. If this analysis helps you follow what is actually unfolding, hit like. I am reading the source documents, not summarizing what other outlets are saying about them. That like tells the platform, this work has value. I appreciate it. Here is why this matters to you directly. If you hold positions in U.S. markets, this situation warrants your attention. Political and legal instability creates measurable portfolio impact. That is not a partisan statement. It is a financial reality. Friday saw defense contractor stocks decline 2.3% in the hours following the Qatar connection becoming public. Institutional investors do not tolerate ambiguity around foreign transaction exposure. Your retirement accounts almost certainly hold positions in companies that are now urgently conducting internal compliance reviews. Not investment guidance, simply what market pricing is already reflecting. On the question of precedent, if a sitting attorney general can be compelled to testify against a former president while delivering corroborating physical documentation, the practical boundaries of executive privilege have been permanently redrawn. The next time that phrase surfaces in a news story, this proceeding is the reference case. Consider this parallel. You work for an organization. Your chief executive instructs you not to create any record of a particular meeting. You create one anyway. Years later, you deliver it to federal investigators. That sequence of events just occurred at the highest level of the United States government. Every future administration will factor this into its calculations. Every future official will make decisions with this outcome as a reference point. Who is directly affected? At this moment, 23 individuals referenced in the portions of BONDI'S testimony that are currently public. 8 named explicitly. 15 referenced through title or positional description. Prosecutors have already identified everyone in that second group. The public has not. Federal employees and agencies connected to this investigation are currently receiving legal hold instructions. Preserve all records. Delete nothing. Those notices go out Monday. The part no one wants to say directly, if these transactions are what prosecutors are alleging, structured to evade regulatory oversight, moved through shell entities tied to foreign sovereign capital, then policy decisions made during the current term were potentially shaped by financial arrangements that voters never had visibility into. Appointments, regulatory determinations, legislative priorities. If you participated in the 2024 election, this story involves you, not through any fault of your own, but the outcomes affect you. If your tax dollars fund this government, the allocation of resources you supported was being directed by priorities we are only now beginning to examine. The intent here is not alarm. The intent is accuracy. That is what the documents are pointing toward. What people who are paying close attention are doing right now, examining their exposure in sectors with political and regulatory sensitivity, monitoring Tuesday's proceedings for the names and full scope that emerge, having direct conversations with their financial advisors about positions connected to companies now under scrutiny. Information is the advantage available to you here. This story has concrete material dimensions. Money moved through real institutions. Decisions with real consequences were made by real people. The accountability for those decisions, whether legal, political, or financial, will be determined in significant part by what exists inside those sealed court documents. Here is the dimension that no one is addressing publicly. Bondi was not a peripheral figure. She was at the center. She was the designated defender. If she has cooperated fully, the question forming in offices across Washington right now is, who else is running the same internal calculation? That question is being worked through in legal consultations and private conversations happening at this moment. The first significant break occurred Thursday. The question now is, what follows it? How did Trump respond? He escalated and in doing so created additional legal exposure for himself. Thursday night on Truth Social, 11 separate posts across 3 hours. He described Bondi as mentally unstable, as desperate, as a disgrace to Florida. The opening post read, "She was never smart enough to understand what she saw. Confused woman." That post generated 4.7 million views within 12 hours. Bondi's legal team filed a request for enhanced security arrangements Friday morning. Republican leadership response fragmented. Immediate defenders invoked the standard framing. This is exactly what the deep state does. Others went quiet in a way that was itself conspicuous. One senior Senate Republican, described by Axios as close to leadership but not named, said Friday, "We need to see what's actually in the sealed documents before anyone should be making public declarations." That is not a defense of the president. That is the establishment of distance. Trump's legal team issued a formal statement Saturday morning. Ms. Bondi's testimony is the product of prosecutorial pressure and personal desperation. We will respond to every specific allegation through the appropriate legal process. Saturday afternoon, Trump's attorneys filed a motion seeking to exclude portions of Bondi's testimony, asserting attorney-client privilege over specific conversations. Prosecutors responded the same day Bondi was not functioning as Trump's legal counsel during those exchanges. She was a witness present when they occurred. That dispute goes before the judge Tuesday. This is not de-escalating. The pace is increasing. Every statement from Trump's legal team produces a prosecutorial counterfiling. Every post on social media is being entered into the record as evidence bearing on intent to intimidate. The current legal strategy is not serving the defense. What remains unknown? The contents of the sealed transcript. Bondi testified for 4 hours. 90 minutes are in the public record. The remaining 2.5 hours are sealed pending the ongoing investigation. That is a substantial volume of undisclosed testimony, the identity of the sitting congressman. Bondi named a current member of Congress. That name is not public. Their office is aware and is not speaking the full foreign dimension. Qatar, the Cayman Islands, Cyprus, 3 separate jurisdictions have been referenced in the available record. The complete picture of foreign financial involvement has not yet been established. More is forthcoming. Judge Mercer has the status conference on the calendar for Tuesday, March 10th. Both parties will present arguments on the privilege dispute. Prosecutors have indicated potential additional indictments as early as this month. The congressman's legal team is reportedly in active negotiation. The parties and subject of those negotiations are not yet known. Tuesday, March 10th is the date that matters. If the privilege motion is denied, which the majority of legal analysts anticipate, additional portions of Bondi's testimony enter the public record. If it is granted, Trump gains time but not resolution. Secondary date, Thursday, March 12th. Grand jury reconvenes. New evidence is expected to be presented. Substantive developments should be visible by the middle of next week. This is the current moment, uncomfortable, unresolved, advancing more rapidly than anyone inside or outside this process anticipated. Subscribe. I will cover Tuesday's hearing as it develops. When the sealed portions are released, if they are released, the breakdown goes up the same day. Turn on notifications. This is where we are. Saturday, March 7th, 2026. Bondi has completed initial testimony and may be called back. Partial transcript is in the public record. Significant portions remain under seal. 8 individuals named directly, legal status unclear for most. 1 congressman identified, name still sealed. Privilege motion filed by Trump's attorneys this morning. Prosecutors have formally requested expedited document production from 4 foreign financial institutions. Upcoming Tuesday, March 10th, status conference, privilege arguments heard. Thursday, March 12th, grand jury reconvenes. March 17th. Next witness testimony scheduled, identity not yet public, not yet accessible, the sealed 2.5 hours of BONDI'S testimony. Any cooperation arrangements with additional witnesses, which prosecutors have not disclosed. The complete scope of the Cayman Islands banking records request. The clock is running every day between now and Tuesday. Legal teams on both sides are preparing briefs, coordinating media responses, managing witnesses. The outcome of Tuesday shapes everything that follows through the remainder of the month. If privilege holds, slower movement, extended legal conflict, potentially months of additional proceedings. If privilege fails, acceleration, more names entering the public record, more testimony, possible indictments before April closes. We're in the gap right now. Waiting. Pam Bondi, cooperating witness, immunity secured, testimony entered into the official record. Donald Trump mounting a defense, attacking publicly, carrying legal exposure that did not exist 1 week ago. The surface read. A former loyalist turns and delivers the documentation. But Bondi did not make this decision arbitrarily. Something drove her to it. Her own legal exposure. Prosecutorial pressure. Possibly something we have not yet been given access to. And the sealed testimony is where the real answer may live. What is in those 2.5 hours that wasn't made public? Who else is named in that section? What transactions are described there? Tuesday's privilege hearing will tell us a great deal about what both sides believe is approaching. This story has not reached its conclusion. It is developing, and the pace of that development is not slowing. What I can commit to, when documents are filed, I read them in full. When transcripts are released, I translate them into language that is actually useful. When expert analysis surfaces, I separate what is signal from what is noise. This is not a space for quick reactions. It is a space for understanding what is actually happening beneath the surface of the headlines. Subscribe for the complete picture. The machinery is in motion. Bondi opened the door. What walks through it next, we find out Tuesday. I'll be here.